This conference will now be recorded.
Was having a great deal of problems with people coming in just having no idea what they were doing, and unfortunately that is still the case, which led me, when I left Tulsa Lawyers for Children, to establish the Oklahoma Family Legal Advocates to help families with those kinds of guardianships. Now the Legal Aid Services of Oklahoma actually have a contract with DHS to provide for those kinds of guardianships. So that is a resource that I think the PARB boards have if they feel like maybe a guardianship with an appropriate parent, an appropriate relative might be better than the child continuing to go through foster care and stay in the child welfare system. That can be recommended that a Title 30 guardianship be considered. And if the family does not have the funds to cover that guardianship, then the Legal Aid Services, it can be referred to Legal Aid Services to handle that guardianship. So just generally the process for filing a guardianship is in a couple of ways. In most cases, especially with children that have been picked up by DHS, and let's say they've had a family safety meeting, and it's determined that the child really can't go home, but there is someone that's available to be a safety monitor. Well, once they have the safety monitor, then DHS will look at that person a little more carefully if the family's not proceeding successfully with the plan that came out of the family safety meeting, or the child safety meeting, I'm sorry, and they may request that safety monitor, who can be either a relative or a non-relative, might consider filing for guardianship if it looks like there's going to be a long period of time for this parent to get their act together. In the past, DHS has really been leery of Title 30 guardianships because they felt like, well, once that parent was let go from the requirements of the juvenile court, that the parent wouldn't do anything, that there would be no guidelines for the parent to actually correct the conditions that may have caused the children to be brought into DHS custody. So we're going to go into a little bit of that in a few minutes. But all Title 30 guardianships are filed and heard at the Tulsa County Courthouse down on 500 South Denver. And I should clarify or give you a precaution here. All of my experience has been in the Tulsa County District Court with guardianships. The majority of the things that I'm going to talk about are also applicable in courts across the state, but I may refer to something that is specific to the Tulsa County Court, and I will try to confirm that when I'm speaking about it. If I make a statement about that, I'll say this is what happens in the Tulsa County Court. So you might want to take a look at where or talk to the judge who handles guardianships in your county to see if there's any other specific things that judge puts in place. But the first thing that will normally happen will be an emergency guardianship. Emergency guardianship is not required in all cases, but it only comes into effect when perhaps the child is when the child's safety is in question, or there is a problem with continuing safety for the child. So to get an emergency guardianship, the petitioner the petitioner is the person who is trying to get the guardianship. The petitioner will have to file all their paperwork on the same day that they're going to have the emergency guardianship hearing. So they have to get everything together, all paperwork filled out, and take it down to the courthouse, get it filed before 2 o'clock in the afternoon, because the court hearings on the emergencies are at 3 o'clock in the afternoon. So they take the paperwork down, and there's a list of pleadings that have to be filed. There's about 10 different pleadings that have to be filed. Some of them are only necessary if the child is in DHS custody. If the child is not in DHS custody, and these guardianships are available to anyone, not just children who are in DHS custody, but those are the ones that we'll be mainly concerned about. In addition to the petition for the emergency guardianship, there's a UCC JEA affidavit. That's Uniform Child Custody Jurisdiction and Enforcement Act. That lets the court know that they actually have jurisdiction over this child. The child has lived here for at least 6 months, and there are other things, and they have to say where the child has lived during that time and who the caregiver was. There is a sex offender registry affidavit. There's an application and release for a background check, which is only the local background check. There will be other background checks after the emergency guardianship is acquired. There's a plan for temporary care and treatment of the ward. There's an order approving the plan for temporary care, order for emergency guardianship, temporary letters of guardianship, order requiring timely completion of background checks. This is a new item that the new guardianship judge has put into effect. And what that does is it requires everyone who gets an emergency guardianship to actually request all of their other background checks within 5 days after they get the emergency guardianship. Then there's a notice of hearing, which sets the next hearing date. And there's an order granting concurrent jurisdiction. That's only required if the child is in DHS custody, whether temporary or permanent or whatever the situation is. If there's no juvenile court involvement, then that particular document is not required. Because the juvenile court has primary jurisdiction over a child, they have to give permission for the juvenile court to proceed with any other kind of action. And that's what that order granting concurrent jurisdiction is all about. Once the pleadings are filed, then all the orders and letters are taken to the judge who will hear the emergency guardianship. And then everybody comes back at 3 o'clock and they have the hearing. Now, if the person doesn't feel like they can afford the filing fee, and we'll talk about the costs and the filing fees in just a minute. If they feel like they can't afford the filing fee, then they will need to fill out what is called a pauper's affidavit. And if the judge agrees to what's on that pauper's affidavit, the judge will sign it, which allows the petitioner to go forward with the guardianship without paying the filing fee. It also means that later on they will not have to pay the annual report filing fee as well. Then after as soon as the emergency, now when we say it's an emergency guardianship, what the petitioner will have to show that there is actually an emergency. They can't just use that to get the child in their custody. They have to actually show that there is an emergency. And normally when I did a guardianship, an emergency guardianship where DHS was involved, I tried to get the DHS worker to actually come to that hearing and then testify why the emergency is necessary. And I've never had one turned down when the worker came and testified. Then all those paperwork is filed, and from after that point, then the petitioner there is an emergency guardian in place who can act as a guardian until they have the next hearing, which is usually within 30 days. And that next hearing is considered a show cause hearing for the emergency guardianship to determine whether the emergency is still in play, still necessary. Then all the the background checks have to be in place. And and one of the challenges is that one of the background checks is a child abuse and neglect information system background check, which we call CANIS, C-A-N-I-S. These background checks are requested by the petitioner, but the results go directly to the judge's clerk. The challenge with this is those background checks are taking from 3 to 5 months and sometimes longer to get back, which means they have to continue having continuances for the final guardianship, because the judge cannot grant a guardianship until those background checks are in place. So once everything's all in place, they've got all the background checks and everything back, they could have the final hearing. If there's no objection, that final hearing goes through pretty quickly. And normally when DHS is involved, there is no objection from the parents, because the parents know that there's either going to be the guardianship or the child's going to go back to DHS custody. So they're more in favor of the guardianship, so that they'll be with a family member or somebody they know, rather than in a foster care with a stranger. If there is an objection, then the parents are entitled to a trial, just like they are in juvenile court, to put on evidence as to why the guardianship's not necessary. But once the guardianship is granted, the parent, the guardian is either requests to be a guardian of just the person of the child if the child has no assets or income. But if the child's income is over $10,000 a year, and the way that can happen is if they're, say, receiving Social Security benefits from a parent, or survivor's benefit if the children are if the parent is deceased. So there is a possibility that the child would be entitled to benefits that might exceed $10,000 a year. And in that case, the guardian has to request that they be the guardian of not only the person, but of the child's property. And there's
Barbara,
yes.
This is just the 10-minute warning.
Yes, I know. I'm looking at my stuff here. Okay. The next thing, we're going to go on to the next thing, the cost of filing. Those are all listed in the paperwork that I've given you, and just so that you'll have that in that list. And I mentioned that either a relative or a non-relative can file for a Title 30 guardianship. If there is a trial, the burden of proof for any kind of hearing or determination of guardianship, if it is not a Indian child welfare case, is a preponderance of the evidence, which is the lowest burden of proof. And that's mainly because the guardianship does not terminate parental rights. So there's going to be a lower burden of proof than if it did terminate parental rights. One of the advantages of the so I'm going to move on to the responsibilities and duties of the guardian are just that they have a higher duty of care for a ward than a parent, because the guardianship's established by the court and they're answerable to the court, and the guardian is not generally a parent. It's possible that they could be, but we're not going to go into that. Then the guardian provides for the basic needs of the child. The review process for a guardianship is that the guardian is required to file an annual report every year saying what's happened to that child medically and educationally, and according to the plan of care and treatment that they had to file originally, and make sure that they're abiding by that plan. Now, one of the things that happens at the final guardianship hearing that I needed to mention to you, and why I've been able to assure the DHS that the parents will be required to do the same things as if they were in juvenile court, is that the court completes what is called court-ordered standards, and those are pretty much the same as what the parent would have to do if the child stayed in juvenile court. They have to correct the conditions that cause the need for the guardianship, and ultimately, if they want the guardianship terminated, they have to show proof that they have completed those court-ordered standards. Now, a guardianship can be terminated by either the parent or the guardian. If the judge finds it's appropriate that the guardianship be terminated, or if the guardian just wants to resign, the judge can then appoint a successor guardian, and or if there's no appropriate successor guardian, the guardians are allowed to resign, then the court would then contact DHS, and we'd be back where we started with DHS investigating and determining whether the parent's an appropriate person. The guardian could also be removed for various reasons that I've listed in my paperwork. Just a quick thing, and I hope Kim will let me run this by for the ICWA boards. All in ICWA cases, the Title 30 guardianship comes under the federal and Oklahoma Indian Child Welfare Act in the requirements that they have to have. In addition to all of the requirements that we talked about for a non-Indian guardianship, the additional requirements for an Indian child welfare case is that the notice requirements that are subject to ICWA have to include the tribe and the Bureau of Indian Affairs, and the notices must be sent certified, return receipt requested. The petitioner must submit an affidavit of active efforts made to prevent the breakup of the Indian family. The petitioner must provide an appropriate witness to give expert testimony as to whether the continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. The challenge to this is that, to my knowledge, only the Cherokee Nation right now is providing an unpaid tribal representative for this purpose. All others who have Indian child welfare cases will be required to hire a qualified expert witness for this person. And that can be fairly expensive, because the majority of tribes don't feel like they have the staff, or at this time, the staff or the funding to provide expert witnesses in anything but juvenile deprived cases. And finally, the burden of proof in an Indian child welfare case is clear and convincing evidence, as opposed to the preponderance of the evidence in a non-Indian case. So I'd just like to thank you, and if you have any questions at the end of my paper presentation notes, which you will get after this is over with, I've given you my email address. If you have any questions, if you like to know about a list of agencies that assist pro se applicants for guardianships, or a list of qualified non-tribal witnesses for expert testimony in ICWA cases, you can contact me. Thank you.
Thanks, Barbara. And
how did I do? 2 minutes.
You did great. You nailed it. You came in, yeah, just a few minutes shy. So, and I think it's important to reiterate too, like Barbara said, like I've said, these can be imposed at any time prior to the initiation of a deprived case, after. They operate very similarly in substance to the deprived case. So a parent's given a treatment plan. They work the treatment plan in the guardianship case. The guardianship is reviewed. And if at any point the judge determines that the parent has substantially corrected the conditions, the Title 30 guardianship can be terminated. And if the court never makes that finding, the Title 30 guardianship can continue indefinitely. But it's very important to note in a Title 30 guardianship that the parents have standing to ask the court to dissolve that guardianship. So essentially, a good example is if the child's removed, let's say they're placed in emergency DHS custody. In the meantime, DHS approves grandma for placement. They place the children with grandma. Mom immediately gets into treatment. Mom is doing very well. And by the time adjudication rolls around, she may have completed treatment and be working on transitioning back into the community. Maybe a great example of how a Title 30 guardianship could be used. So they are a great option. They are definitely options that I think with proper training and knowledge, that is an appropriate recommendation for PARB members. Now, I often get asked the question, when do you recommend a Title 30 versus a Title 10? Well, that's what your PARB chairs can hopefully guide you through. Keith can guide you through. You're welcome to reach out to me, Christina. I think one big difference is timing. I tend to think Title 30 guardianships are a little bit, I want to use the right word. I don't want to say easier, but they tend to be more popular earlier in cases when we have a very strong, suitable guardian that does not need or have to rely on social or financial services to maintain the guardianship. I think that's huge distinction. I think the child's age is particularly important. And I think that the overall, family dynamics and history is important. So I wish I could give you all a rubric. I mean, I probably could if I sat down and really thought through it, but it is a good question. It's one you'll probably have often, and, there is no magic formula. That being said, don't freak out at this slide. This is really the statutory requirements, and I don't ever like to mix or cut things out too much when I'm copying and pasting a statute. But I did slightly here. I'm not going to go through these. Here is, though, the main points. For a 10A guardianship to be imposed, the child has to be adjudicated to be a deprived child. And the parents can consent, have their rights terminated, or there must be a finding that they failed to substantially correct the conditions that led to the child's adjudication, or they are judged as incapacitated or incompetent, or they've abandoned the child. So the first one is a requirement, the child's adjudicated. Then the parents must meet one of the conditions listed there. And Roman numerals still from the statute, but basically those right there, the parents must meet one of those conditions. The child must consent when the court finds that the child has sufficient intelligence, understanding, and experience. Generally, the law looks at that age as 12, but it can technically be earlier. Termination of the parent's rights is not legally possible, not in the child's best interest, or adoption is not the child's permanency plan. There's lots of reasons why terminating parental rights might not be legally possible. I think that's actually an interesting misnomer, because one of the primary reasons to consider Title 10A guardianships is also judicial efficiency, and looking at the overload weight of our courts right now, particularly in the middle of a pandemic. Another reason why guardianships are becoming a more popular permanency option, because we can achieve permanency quicker. And the child must reside or was placed with the proposed permanent guardian for at least 6 months, or the proposed guardian is a relative. So again, you don't need to memorize these. That's why I put them in here, so that you can keep this presentation and refer back to it when you're like, what are the requirements? Here are a few prohibitions on guardians. I think they make total sense. If they were denied as a foster parent or adoptive parent, if they're subject to the Oklahoma Sex Offenders Registration Act, or if the child's parent had his or her parental rights terminated. Now, this is an interesting and a recent add to the statutes. When Title 10A first came out in 2009, this third point was not included. And so quite frankly, and quite frequently, guardianships were granted to parents. Barbara hinted at that. And people are like, well, why? Well, a good example is, child came into custody at, let's say 10 years old. the child, mom, parental rights were terminated, and the child has continued without a permanent home in custody. So now the child's 13. They've been in several different foster homes or several different groups homes. They were not able to find an adoptive placement, or if they did, it wasn't successful. And 3 years down the road, parents have made substantial progress on the issues. They received treatment, they tested negative. And so DHS would sometimes in the state, I don't mean just DHS, heck, a lot of times the request would come from the child themselves who wanted to go back home with mom and dad. When this particular component was added, that eliminated that what I would call, I mean, some people would call it a loophole. I don't know that I would call it a loophole, because in all honesty, in my 17 years experience, I saw this happen successfully on a number of occasions, where parents, weren't in a place at one point to achieve reunification, but down the road they were. And because we do have a statute that allows reinstatement of parental rights, but that's very, very specific, and not a lot of cases meet that threshold. This allowed that opportunity, if you will. But there is also the rationale that if parents' rights were terminated, it may not be the best solution. And it often left parents, because if parental rights were terminated and they looked at a guardianship, parents could not receive financial support or services. Termination, oh wait, hang on, I think I skipped a slide or two. Okay, so the process, very, very simple. A motion is filed by the state or child's attorney. The parents are served. There are criminal and child welfare checks on the potential guardians. If the current potential guardian, is not already an approved foster home, then there has to be a home study done on that potential guardian or guardians. So if they are already an approved foster home, then the foster care assessment is used. If not, then the state completes a home study. As we discussed, and as Barbara mentioned, parents can consent to the guardianship, or they have the right to request a non-jury trial. They do not, unlike termination, they do not have a right to a jury trial. Hence, one reason why permanent guardianships can speed up the permanency process for children, because it is just a non-jury trial. Burden of proof. Now, there's been some debate about this. I put the higher burden of clear and convincing evidence because it is intended to be permanent. So it is not intended to be undone. So the burden is a little bit higher, but there's been some dicta in some cases that suggest that potentially the guardianship could be preponderance of the evidence. In all honesty, I haven't obviously filed a motion in 10A on a 10A guardianship in quite a few years. So I went with the higher burden simply because you can't go wrong. Meaning if you meet that one, you definitely meet the lower end. The responsibilities and duties of a guardian, they are the exact same as Title 30. And I also provide the hyperlink to Title 30 in this presentation so that you can review those responsibilities and duties. Generally, in a Title 10A, you do not want the guardian to require protective supervision or preventative services, meaning if we're looking at a placement for the child where, and I hate to use this terminology, but it's very frank, but it's very honest, borderline placements, those are generally not successful permanent guardianships. You're really going to want to assess the stability of the placement. The proposed permanent guardian is committed to providing for the child until he or she reaches the age of majority. Unlike a Title 30, where the mentality is this is temporary, in a Title 10A, the mentality is this is permanent. The proposed permanent guardian agrees not to return the child to the care of the person from whom he or she was removed, nor allow visitation without the court's approval. So this last sentence I really should bold, because without the court's approval quite clearly suggests that the court's approval for visitation is an option, and it is. In 10A guardianships, it is absolutely feasible for the courts to impose a visitation order with the biological parents. And quite frankly, I think depending on the circumstances, if, Title 10A guardianships are probably not the right guardian or the option if there is a severe safety threat from a parent. So if there is a parent with a chronic history of abuse or neglect, and that guardian has a hard time resisting those efforts of manipulation or abuse or neglect, probably not the maybe case for a 10A guardianship, and probably definitely not the case where the court would allow visitation. But if you have a parent that simply for a number of reasons is unable to establish a safe, because the key word in these deprivation cases is safety, a safe home, then there is an argument that visitation and that continued connection with their biological parent is extremely important. And I know most of the older clients that I have represented, because I personally believe 10A guardianships are ideal for older children in particular. I think they can be very good for younger, but ideal for older. Most of my clients want that they don't consent to an adoption because they don't want their parental rights terminated, but they're happy where they are. They like their foster home, they like their family, but they don't want parental rights terminated, and they want to visit with their parents. And this allows a absolute, I think, ideal situation for that. Again, the effect of the guardianship, it does not terminate parental rights, but it does transfer all parental responsibilities and duties to the guardian. So education, medical care, etc. Again, you can reference those in Title 30. Parents do not have legal standing to request the guardianship be terminated. That's, I think, one of the, if not the biggest difference between a Title 30 and a Title 10A, is that in a Title 30, as mentioned, but I want to reiterate, parents always have the ability to go to court to ask that the guardianship be dissolved and to prove that they have made substantial progress. In Title 10A, they do not have that standing. So they can't do it. And parents are ordered to pay child support in a guardianship. Now, whether or not we actually ever collect that is a totally different situation, but it is ordered. Review process, super simple, guys. The guardian must file an annual report and or appear for a yearly annual review. DHS has no additional responsibilities after the guardianship is imposed. It is not monitored by DHS. Termination of the guardianship, again, the motion can be filed by one of three people: the state, the child's attorney, or the legal guardian. They are entitled to a hearing on the motion, and if terminated, custody of the child returns to DHS, not the parents. So I want to make that clear. In a Title 30, if a guardianship is terminated without the appointment of a successor guardian, custody will revert back to the parents, even if the case was initiated by DHS, or by a removal by DHS, I should say. In a Title 10A guardianship, it automatically reverts back to DHS and the deprived case. So these 10A guardianships, if it helps you visualize them a little bit more, they are filed within the deprived case. They are not a separate petition like the Title 30. So the Title 30 is filed in family court, and it is confidential, and it is a separate case, a separate petition. In Title 10A guardianships, they are filed within the deprived case, or the JD number, and they are not a separate petition. They are a separate motion, but not a separate petition. So in the event that the Title 10A guardianship is terminated, the original adjudication order that gave the court and the state custody of the child has never been removed or changed or altered. So custody reverts back to DHS, and DHS basically resumes custody of the child, temporary custody of the child, and then starts the process over. So parents are served, but not in the guardianship. They're served in the deprived case. And at that point, because their rights were never terminated, they do have the right to continue to work services if the case goes that direction. And now I'm not going to go through this, but I wanted you all to be aware that this exists. There are supported guardianships. And therefore, unlike a Title 30, which I'm not very familiar with the supports, but I don't think there's nearly as many outside of child support as there is in a Title 10A. In Title 10A, you have 3 different types of supports. You have a TANF supported guardianship, which is temporary assistance for needy families. This lays out the requirements to meet that and what the assistance includes. So I'm not going to go through the requirements, but I am going to say the assistance includes a monthly payment. It's usually less than foster care, but close to it. A Medicaid card, and an assigned adult and family services worker who will provide referrals for services when needed. That tends to be more child related. So if the child's in need of services, continued therapy, treatment, etc. Then you have the Title 4E subsidized guardianship program. And this can be applied to Title 30s as well. So this has a lot, you can tell basically because it's authorized by funded by the federal government, Title 4E funds. It has a lot more requirements on it, but they all are generally, they make sense if you read through them. The assistance includes, again, the attorney will be paid who files the Title 30, monthly standard payment for the child. The payment can be adjusted periodically if it needs to be. Medicaid card, right to a fair hearing, and there is additional services and assistance, which basically can be negotiated under the agreement. This type of guardianship stays in effect even if this type of supported guardianship remains in effect even if the guardian were to leave the state. And then a state-funded guardianship, which again, the assistance includes simply a monthly payment standard for the child. And that's all set by DHS's regulations. They have a scale you can access that will kind of tell you how they determine the monthly payment. So that's a very brief overview. I always include in every presentation I do the stages of a deprived case, just so that, if you're visual and you kind of need to know where things might fit in, that helps. And then these are your important statutes to review. This is Title 30. This is the Title 10A. These link specific to the guardianship statute, specifically to the 10A permanent guardianship statute. But I actually think the best resource on this is the DHS policy. Not only does it walk you through the statute, but it walks you through the different types of supported guardianships, again, what they offer, as well as DHS's instructions to staff, meaning how DHS and what they must do at each phase in these guardianships. So that is my conclusion. We are a little bit early, yay. Now I am going to open it up to questions for anybody that might have them.
This may be a rather simple question, but how do you access the DHS policy on this subject?
Yes, I linked it in that slide in my PowerPoint when I send it to you. The second, I actually had 2 more slides, which basically said, it gave you the PARB staff, Keith, Christina, myself, and I cut it off, but my contact information there is Keith is there, Christina's there. You can always call or email us, but I'm going to get your email contact from Keith in the next day or 2, and I'll be sending that to you. It's the probably second to last slide, and it's a hyperlink. It says DHS policy, and you can just click on it.
Oh, that's perfect. That'll be wonderful.
Yeah,
because there has been some discussion of this recently, and so it's coincidentally come to the forefront. So this is something that we need to become more familiar with. We haven't dealt with it as much in the past.
I agree, Cindy. I agree. Again, I wanted to put together this training. I talked to Keith, and we kind of tossed around topics, and You know, he's always great to give me a little free rein. And I really wanted to put this together because, again, from the top down, DHS is advocating for these guardianships as a very feasible option for permanency for kids, and they are. When done well and when done right, I think in most aspects, they are, particularly for older kids, you know, who really tend to crave that connection a little bit more, a great option for our kiddos. And so, yeah, any other questions?
I put your email in the chat box there.
Oh, great.
I noticed when I hit reply all earlier on some of the emails that you sent out, some of them bounced. So maybe if people don't get email from you in a couple of days, maybe they should send you or me an email just to make sure that the email didn't bounce.
Okay.
I put Barbara's email on there as well.
Yeah, Barbara is like a wealth. She's done it all. So, and one of my favorite things about Barbara is that she will always take your phone call, text, or email. She is truly one of those people that will give you, you know, her advice. You know, she can't, I don't know that she takes cases anymore, but she certainly will talk you through questions or recommendations. I tell my PARB members, I encourage you, if you are in a county like Creek, we have a couple from Creek County, we've got Mays County. If you are sitting in your meetings and you are like, I wonder if this would be a good option, please call me, please call Barbara, please call Keith. Like, you can call me right then. You don't have to wait. Now, you know, I suggest sometimes phone calls when I don't recognize the number because of my career path for years, I got some crazy phone calls. So I don't always pick up numbers I don't recognize, but you can text me absolutely and say, this is so-and-so from Creek County PARB, and I have a question about guardianships. And as long as I have my phone on me, I will answer you immediately. And I encourage you to do that. And like I said, this was a very brief, a lot of information. I encourage you to read through, you know, what we send out, because it just is going to help solidify your knowledge. And I'm done. I'm going to turn it over to Keith if he has any comments in conclusion.
Well, I was going to say, you've got another question there on the chat from Gianna.
I do?
To the guardianship state, the family member is financially responsible for the child.
In a Title 30 guardianship, well, in either guardianship, unless they receive some form of support, then yes, the family member is going to bear the financial brunt of responsibility. Now, as I mentioned, child support is ordered in both types of guardianships, but that's only as good as the parent's ability to pay. Title 4E is available to Title 30 and Title 10 guardianships as a financial support, but you have to meet those requirements. And if you don't, then it's not available. Now, in Title 10A, you have a couple additional options for support. You've got TANF and you've got state, but again, they require meeting certain requirements. But I hope that answers your question, Tiana. Does it? Okay. Okay, Keith, you got anything in conclusion? If not, I promised we would wrap up at 8 sharp, and we may be early.
Not really, except thank you both. I mean, you and Barbara are definitely the legal experts, and usually if your PARB is struggling with a legal question or just a question in general, someone else is too. So reach out to me or Kim or Barbara. Preferably include me in there, because then I can send out that information to everybody really easily. But you know, don't hesitate to reach out. I mean, I can't speak for Kim, but I get a little lonely in my little office sometimes. So if you have some questions, I haven't been able to travel. It's so nice to see a few people. I haven't been able to travel like I used to. Hopefully soon. But just reach out, because I'm sitting around, and I know Kim and Christina are too, waiting for someone that they can help. So anyway, thanks for putting this together, and thanks, Barbara, as usual, for everything.
And thanks, Keith, for being willing to entertain the idea, and thank you to each of you for taking your time and attention tonight, devoting it to this. And we are, again, available if you have any questions. If not, have a wonderful and safe holiday season. And those of you from Tulsa County, I'll see you in January.
We hope.
Thank you all.
Well,
Thank
bye,
you.
guys.
Bye-bye.
Bye.
Thank
Merry
you.
Christmas.